All right, everybody, we're ready to get started again? All right. My name is Michael Barrett. I'm a defense attorney with Burness and Bowling in Birmingham, Alabama, doing workers' comp defense. And I'm going to be introducing our next speakers who are going to talk about workers' compensation and case management. First speaker is going to be Ann Benefield. Most of you may already know. She's an RN field case manager with VONA Case Management. She graduated from the Mobile College School of Nursing. Doesn't say what year, but she practiced as an intensive case nurse at the Mobile Infirmary and also at Providence Hospital, where she was a member of the code team and was certified in critical care nursing. She later graduated from the University of South Alabama with a bachelor's in healthcare administration and accounting. She has 30 years of experience in case management and is CCM certified. She is licensed through the state of Alabama with the Registered Nurses Compact license and has experience in state, longshore, and Jones Act claims. Speaking with her is going to be Craig Martin, who is a partner at Brady, Radcliff, and Brown in Mobile, Alabama. He's an experienced defense attorney who has extensive trial experience, both jury and non-jury, in Alabama state and federal courts. He practices in personal injury defense, premises liability, products liability, workers' compensation, and occupational disease cases. He regularly represents employers, premises owners, and corporate clients in a variety of general liability matters arising out of claims for personal injury and wrongful death. He's been asked to speak at many seminars and conferences on various topics, including Alabama Workers' Compensation Act and HIPAA, which is this easier way to say it. They're going to go over different aspects of workers' compensation and case management, and I'll go ahead and turn it over to Ann.
Thank you very much.
You on?
Okay, before I get started, I'm just going to briefly tell you that apparently there was a poll taken about what we need to do when we start this speech or this talk. And I didn't know any of them, but Kyle was telling me when he mic'd me up to speak up. So thank you, Kyle. Several people came in and said, okay, take a deep breath and then exhale slowly. So we're all going to do that together now. Okay, everybody, 1, 2, 3, deep breath. Exhale slowly. And y'all all made me just feel so much better. Okay, and then I'm supposed to find people to look at. So I'm thinking that I'm going to look at you and you and you and you. And you know, the rest of you, I'm sorry. Then the other thing was to tell a joke. Craig and I got together and neither one of us can tell jokes good. So I'm thinking that maybe he told our joke, but if somebody out there has a good joke they want to share with us right now, we are welcoming it. So feel free to tell us a joke.
It's perfect time for an icebreaker, right?
So, okay. We are here to talk about, our topic has kind of evolved and changed once we got started on it. There were a lot of things that were put out to us to talk about. And so we thought that we might do it from a medical and a legal viewpoint. So just to kind of briefly go through it, the role of a case manager, the referral starts out when the employee has the injury. The employer reports the injury to the adjuster, all the conversations between the employer and the adjuster at that point, of course. And then it kind of evolves into where the adjuster is talking to the employee. They get the statement, do everything, find out what they need to know about it. And then there becomes a physician involved, or the authorized treating physician. The adjuster goes through this and decides whether or not she needs eyes on, which is what we do. Case managers observe, and we gather the medical treatment and we coordinate it. We do not approve or deny treatment. So anytime that an injured worker, is upset because something's not moving fast enough, it is because all the information is still being gathered oftentimes. At the point that the adjuster decides that a case manager needs to be involved, then we try to become that center of communication for everybody. We want to be the person that everybody is talking to, so that the adjuster's phone's not ringing all the time, and we are updating and providing the information that she needs along with the medical documentation that she needs or he needs. So at that point, we become the hub. We schedule and attend all appointments as long as it's an on-site case management appointment, or if it's a task, then we handle everything telephonically if that's what's needed. If the injured worker is represented, then of course we have to go through Mr. Attorney to get approval to have contact with the injured worker. And that is where we kind of know where we stand with everything then, and that kind of keeps us going in our flow for what our communication is.
Okay. Yeah. So as Mary Ann said, I was going to kind of speak as we were going through this about, from the legal perspective, what it is that y'all do that can help us. But before I begin, I did want to make two observations or two statements, and wanted to thank y'all for having us here today. And kind of occurred to me as I was sitting here up on the stage, looking out at everybody eagerly looking at us. I kind of wish I could be like Oprah and look at you and say, you get a car, you get a car, you get a car, because everybody's so nice and smiling. But alas, you've got case management. So anyway, that's what I intend to talk about a little bit is just from, as Mary Ann said, the legal side. So we have, two topics that I was thinking about is what can a case manager do to assist an attorney? And more importantly to you, what can you do to kind of keep yourself out of trouble? And I don't mean trouble, kind of, that's a scary word, but I don't want to be put in a situation where I'm going to walk over a line. So just maybe we'll talk about some of the things that I've seen, or, what I can do, or some advice I could give you about doing that. So kind of topic one was, how can I case manager assist attorneys? And I said two observations. I guess I should have said three. So when Mary Ann and I were talking about this, we very much would welcome questions from anybody. You're certainly not offending me if you interrupt me, because frankly, I think this would be better to be more conversational instead of me being a professor up here and just, spitting out a lot of law to you or observations. But again, at any time, if anybody has a question, please raise your hand and let us know. So obviously I practice defense work, but I think most of this would apply to anybody that's an attorney on either side. But obviously when I get a case, it usually means the employee and the carrier can't agree on the value of the case. Again, Mary Ann could certainly speak to this, but there's a breakdown by the time it's gotten to me. So first thing I need to do is identify the judge. That's really for me. It's really kind of one of the most important people for my case. But really, and again, as I look at this from the case manager perspective, the second step is I've got to figure out, well, what are the disputed issues here? All right, where's the breakdown? What are they disagreeing with, the employer and the carrier on the facts? And what are the medical issues? Okay, and again, talking about the role of the case manager, that's where you can come in and certainly help. Again, well, we'll talk about the medical issues. If we go to the next slide, again, from my perspective, the medical record clearly is one of the most important things to help me do my job, okay? The case manager, Mary Ann, you've got a relationship with the doctor. You've been speaking to the doctor. But again, by the time it gets to me, that record's the most important thing, all right? So whatever facts, whatever observations, whatever is in there, that's what I've got. I haven't spoken to the doctor yet, so that's what I've got to go on. So again, these are things that I know, but just kind of as number one in terms of what would be helpful is to encourage that doctor to clearly document the medical record. We'll get into some of these issues later, but if, again, I think most of this happens, but just as an example, if you've got a lower leg injury, okay, well, that's kind of broad. I mean, he's going to talk about an ankle, he's going to talk about a knee, but, is there any pain in any other parts of the body? Okay, these are just issues that if we can get it clearly nailed down at the start of the case in the medical record, that saves a lot of disputes, a lot of arguments down the line. Would I be kind of out of line to suggest that's probably one of the most important things that y'all do?
Yeah, clarifying all body parts from the beginning is usually one of the first things that we're asked to do from the first report of injury. And then if all of a sudden the patient starts talking about oh, my back hurts and it's a leg injury, then, of course, the first thing that we're going to hear is, well, it's an altered gait and those sorts of things will, and how quickly all of that is going to get remedied and if it's really a part of the work injury.
Yeah. And, some other examples. And again, I know everyone does this, but it's not just so much the body part, but pre-existing injuries. Okay. And again, every medical record's got a past medical history in it. Every doctor asks for it. But again, that's important. I don't know the extent that the employee has gone into that with the physician, and I'm not suggesting it's the case manager's role to go in there and say, well, look, you forgot to do this, or you need to do this better. But these are just some issues. Obviously, if the injured worker from my defense practice has got some pre-existing accidents and injuries, certainly to the same body part, I need to have that covered, and it needs to be in the medical record. But again, those are mostly but these are just examples. Obviously, causation is a big one. Doctor's going to get to that later. That's not so much that there's something that they're going to do at the outset, but perhaps they can at least note in the record the history of the accidents. We talked about past medical history, but certainly the history of the accident itself. And I would just, okay, sorry, go ahead.
No.
I think it's on the slide, but again, the reason why the record is the most important thing to me is because once it goes in there, I don't blame the doctors. They see tons of patients, but I have found by the time I get into the deposition with the doctor many months down the line, he or she is simply going to read that medical record back to me because that's what is in there. That's what they remember. So if there is not information in there, well, doctor, did he tell you X, Y, and Z? Well, he or she cannot remember that. They're going to probably just go what's in the record. So again, these issues that if we can get them into the medical records early, it's certainly a benefit to me.
And one of the things Craig and I have been talking about, and I often speak to with adjusters and other attorneys, is that we're looking at it as case managers from the medical side of it. We're not looking at it necessarily from the legal. We learn it as we kind of go, what kind of we need to nail down and get for them. But oftentimes we have to have some direction from either the adjuster or the case manager for what they need to be able to have all the documentation in place as far as clarification, causation, and those issues that are so very important when they're trying to resolve the case. And just to touch on like the legal issues, I wound up in court 2 times in October, and the first time was not because they had a problem with the case manager, but it was because we were being accused of, or the adjuster was being accused of delaying the treatment. Well, when I got the timeline together for how everything occurred, there was no delay in any treatment. As a matter of fact, the treatment was done immediately. And so we were able to produce that to the judge, and we were able to just show him the timeline, and the medical record all supported it, which was great. The second time that I was in court in October was because an injured worker had accused me of calling him a faker. I mean, you may think it, but you're not going to say it out loud. But the fact of the matter is that had it not been for the documentation that I had, where I had spoken with the physical therapy, who he said told him that I said he was faking, then I would have just been in trouble. But we had documentation that showed that I had followed up with the therapist. I had even documented to his attorney different things and everything. So your documentation is very, very critical, not only to help with the case, but with yourself, because you don't know what someone's going to say. Now, this injured worker actually was representing himself, believe it or not. He didn't even have an attorney, and he was doing a broad stroke with slander on everyone. But you do have to have your documentation in place, because if we had not had that, I don't know what would have happened.
I'm curious how impressed or unimpressed was with the judge with the accusation of slander.
he was not overly impressed when he saw the number of people he had accused of it.
I think so, but no, great point about you certainly want to document and protect yourself.
Yeah, and one of the other things that Craig and I have been talking about in all of this was, of course, we're living in the pandemic era, and that's new for all of us. And one of the things that I was asked to bring into this was the whole COVID. How has it affected us as case managers? Well, we all went through that time period where we were at home and we really weren't able to get out in the field. It happened and then it kind of passed, and it might have been longer in some areas than it was in others. Down in Lower Alabama, we really were not out of the field very long at all. And we followed the protocols and everything. And really and truly, I think, and Ashley, some of you other case managers who can help me out here, I don't think we saw as many cases of COVID in that first go around in 2020 as maybe what we've started seeing recently. And the big issue for it has been that it delays the treatment. It absolutely delays the treatment. And I have some doctors who say, well, I want to see that positive COVID test. And Craig will speak to that in a minute. And I'm like, well, I don't have the positive COVID test, but even if his family's tested positive for COVID and he's living with them, then we got protocols of them being quarantined 10 to 14 days with or without symptoms or whatever. So any of you other case managers seen much going on with COVID over the last, 4 or 5 months?
Yeah, this
Yeah, and just to add to that point, at least from my
You did?
attributed to COVID. Well,
Wow.
just from my perspective, just to finish that point, obviously the bench trials in a comp case, they don't have the challenges that to get a jury in there. So those have been rolling along. We haven't seen much of a slowdown. As you mentioned with the Delta variant, there were some times certainly when things were impacted a little bit, but I haven't seen a bigger impact on the comp aspect since they're non-jury.
No, I think that by and large, the cases have continued to flow. And to the point of a physician asking to see the positive COVID test, I've got some patients that will send me their test in a text, and they just do it. I don't ask for it, they just send it to me. I've got others that they would probably have to be subpoenaed to give it to you. So, did they have it? Did they not? I'm not sure that that's really something a path that we have to go down. The fact is that, they do their quarantine period and then we're back on track again. And as you know, the standards from the CDC have changed drastically almost every day for what they want to adhere to. But I know in Mobile right now and in the Baldwin County area, most of the doctor's offices they're stopping the mask procedures, no more testing, taking temperatures. You're pretty much free to come and go as you want to. There are a few that still, especially if they're associated on a hospital campus, that you still have to wear a mask and do their protocol. But by and large, it's seems like it's settling down some.
Yeah, that would be my impression as well. I would like, if it's okay, to finish up this point. We just, getting back to the record so we can move on to some other areas. I've got a list of some things, again, as just I have an intake of the record and reviewing it in order to get the case ready to either be settled or tried or resolved. We touched on the first one being the areas of the body affected by the injury. We kind of talked about this, and this would be important. We kind of talk about the schedule. I'm sure you've heard that. I know our lawyers in here know the schedule in Alabama. But for example, and we'll get into this a little more in depth, but if you've got an injury to one body part, okay, just say it's to the elbow, is there pain? Is it extending to other parts of the body with the shoulder, which would take the injury outside the schedule? So again, just kind of clear documentation, not only the body part that is injured, but almost talking about whether that is confined there and nailing down that injury does not extend to other parts of the body. Malingering or symptom exaggeration. Just again, this is not so much a case manager issue. That's what I'm looking for. Obviously, as a defense attorney, I want to look at the plaintiff's credibility. A lot of the times the doctors will mention that, whether they feel that the claimant, the employee, has been fair with them. And again, this kind of gets back to asking about the prior medical history. I cannot tell you the number of times I've been in a deposition where the employee has given a history that's a little bit deficient, so to speak. And I come in there with some past medical records and I show the doctor, well, did you know about this? Did you know about this? Did you know about this? And I've never come across them, or every single time they're very furious. And the testimony usually will be a little slanted towards away from the employer at that point in time for obvious reasons. The doctor feels like the employee is not shot straight with him or her. So again, just any type of history, lingering symptoms, inconsistencies, same thing. Maximum medical improvement. Again, all doctors know this. They're doing this as, again, I know you know this as well, but that would obviously be the cutoff point between temporary disability benefits and permanent benefits. So that's a very important thing for the attorneys, both sides, to know. When is maximum medical improvement? If, in the normal, you will say, I intend to have the employee come back maybe one more visit, at which time I'll place them at MMI. I just want to kind of give you some background as to why that isn't so important to us, because for a legal perspective, that is the kind of the dividing line between temporary benefits and permanent benefits. The impairment rating and restrictions, again, things you all know, the doctors know. I would just add, again, the restrictions are very important. Once you've got those restrictions, if you're dealing with an unscheduled injury, that's when we then bring in a vocational expert that can kind of look at the case, work it up, and we can kind of get a value of the case. So again, restrictions is another key time in the life of the case. Once we have those, we can, move it towards a resolution.
And if I can just speak to that point for a minute, because it's moving right into the FCE area of it. A lot of times now what we're seeing in our area, and again, I can only speak to the area I'm in, but a lot of the doctors now are willing to do a full duty trial rather than just jumping into an FCE, just do a full duty trial, return to work, so that we give that employee a chance to get back in that process of working again and get that mindset changed. And I have seen personally that has benefited and saved FCEs numerous times now. Some adjusters and some companies, they want FCEs. Some doctors across the board just want to do FCEs because they feel like they're not vocational experts and this is not what they feel qualified to address. So they want that FCE. So at that time, it becomes very important that we get them to a facility that is actually going to give us something that we can take back to the doctor that shows the validity and the malingering and symptom magnifications and the things that Craig has been speaking to. But, knowing your surroundings and knowing who you've got available to you and the results that they do is very important to you as a case manager, and sharing that information with the adjuster so that, they can make a qualified and a good decision as far as where they want to send that patient if an FCE winds up being done. But I would always encourage, since we're seeing this work out so much in our area, to see if they would release them to a trial, even if it's a trial with some restrictions. Get them back, especially if they've been off for a little while, get them back out into the work world, help change their mindset, because they do get very set in their mind about being off work. if they're off for too long. And we always said like 6 months is the line in the sand, that if you go past 6 months, it becomes more and more difficult to get someone back to work. But sometimes they're having surgeries and such that you just can't get them back before then. And sometimes the employer cannot accommodate. But for the employer to be, and again, it's part of our role, if the adjuster allows us to have conversation with the employer to help the employer understand how important it is to get this person back on the workforce, get him back on their payroll and off of the work comp payroll. And sometimes that's a hard thing to do. And, you know, sometimes you're thinking, oh God, I'm never gonna get this person back to work. And they're like, oh yeah, I'll go. You just never know when you walk in.
Yeah, I was just going to add, just, you know, I didn't know the statistic off the top of my head, but 3 to 6 months is kind of what I'd heard. You'd mentioned 6 months, at which time, if the injured worker is not back at work, I think the odds plummet at that point in terms of maybe a successful return to work. So again, you know, certainly we're going to adhere to what the doctor has to say, but if the employee is willing to, I think that would certainly be a benefit to actually to all parties at that time. Before we move on from the record, again, I know very kind of straightforward, but were there any questions with respect to what we've discussed before up to this point? Okay. I think, again, so from my perspective, I just maybe was thinking about what would be some relevant issues for the case manager in the intersection of how I do my job. Again, some of this stuff is very obvious to you, but perhaps I can also explain, you know, why that is and why that's important to me. So, you know, communications with physicians. I think we all know that the case manager can have oral communications with the physician. You know, that came about, there was a case back in '99, Smitherman case. I think at that point, the claimant's attorney had suggested that you could only have written communication. Now, let me back up a little bit. I jumped into Smitherman, but the code itself allows each party's access to the treating physician, and that is without notice or consent to the other party. Now, that does do with written opinions of the doctor. Okay, so let me back up again. If, for example, the adjuster that I'm working with wants a written opinion from the doctor, we're authorized under the statute to, you know, make that request without notifying or without consent to the injured employee. But just on the issue of oral communications, again, I probably feel like we know we can. The case manager can speak orally, and so that is allowed under Alabama under the Smitherman case. And obviously HIPAA does not affect that rule. Just again, there's a specific carve out under HIPAA for workers' comp. Yes, ma'am.
In the last year, we had a certain plan insurance that has been case managers
As I understood the question is you're receiving letters from, okay, claimant attorney that said after a period of time is what I heard you say that you could, once this letter that you cannot have communication with the physician. No, okay, just based on those facts alone, and there might be other circumstances I don't appreciate, but no, you are entitled to have communication, oral communication with the treating physician. Now, we've all heard, and I know Mary Ann could probably speak to that sometimes y'all get these letters that says, look, I don't want you to have contact with the claimant, with the employee. I understand that, it's fair enough. And perhaps also I would agree that you have no right to be in the room with the claimant as he treats with the physician. But you do have that opportunity to speak to the physician after that appointment. Okay. I'd like to talk to you afterwards. We certainly talk some more, but based on kind of what you told me today.
Yeah, it's really, the letters and the conversations with the plaintiff attorneys are really ingenious sometimes because they do flex their muscles a lot. And we've got one in Mobile particularly that his rule is that you can talk to the doctor, but only in the presence of his client. Well, You know, there are times when we go in and clarify treatment and we don't want that client there at that appointment because we're clarifying treatment. But most of what we do can be said and done. I mean, all of what we do can be said and done in front of the client. That
Yeah.
is not the problem. The problem is that that doctor may not have the time to see this person and then stand there and go back in the room with this person again and talk to you and rehash the same thing.
We got a request to repeat that question that was asked from the audience.
Okay.
We couldn't quite hear back here what the question was to you guys. Could y'all repeat the question that she asked?
Repeat the question. As I understood, again, the question was the case manager is receiving a letter from the employee's attorney suggesting or stating that you no longer may communicate with the physician upon receipt of that letter. Is that right? Okay. Sorry, I think we lost track. Were you?
No,
Okay.
I think it's good.
Yeah.
I think
Okay.
it's good. Any other questions along those lines or anything other people are seeing out in the field, getting letters, phone calls from attorneys?
Mhm.
You know, they're attorneys, they're used to it.
Well, that's right. That's perfectly
Right
natural.
there.
Yes, ma'am.
Not really a question, but a comment. In our company, we have a policy that after we've received our case manager guidelines from an attorney, either written, verbally, whatever, we compose a letter, send it to the attorney restating, sort of as an affirmation that we understand.
Mhm.
If, in the case where you mentioned an attorney who requests that we only speak with the physician in the presence of his client, it's become standard for us that we note that
Mhm.
request and then say, we will do our very best to honor that.
Right.
request.
I think that's fair.
And
Right.
Yeah.
We have made that statement because like you said, there are many times where we're waiting, doctor in and out, and, you know, you haven't had the opportunity.
And again, that comes down to really good documentation on your part because the attorney sent you a letter and you responded in a letter. You did not disagree to not do it, but you know, you're still working within the scope of what the state of Alabama allows you to work. And, you know, they're going to come in and they're going to ask and again, flex their muscles and try to get us to, you know, back up because the goal has been for many years in Alabama to get no ex parte communication. I mean, they have worked for it many, many years. I mean, God, I've been doing this 30 years and it's come up many times.
Mhm. Yeah, I was just going to add, actually what Marianne said, I think that's great for two reasons. Number one, you're documenting it correctly, protecting yourself, but just being above board, frankly. But two, you know, you're trying, you know, as Marianne said, frankly, you should be able to talk to the doctor in front of the injured claimant. That's your role. There's nothing to hide here. So, you know, when you're saying we're going to do our best to accommodate that and you're putting that in a letter, I think that's a very good way to handle it.
Mhm. Anything else? Thank y'all for your feedback. This is great.
Yeah, thank you. You know, again, so I'd say the next issue that I just want to briefly touch on is the schedule itself. I had mentioned it earlier. Now, Marianne, when you're dealing with a body part, an arm or a leg, that is actually to be compensated differently from a back or a shoulder under Alabama law. That's not a you issue, that's a me issue, but this is what's important to me.
Mhm.
So the schedule, well, and why frankly the schedule makes a big deal is that frankly the value of the claim is much greater if the plaintiff attorney can take it off the schedule. So if you have a back or your shoulder, the value of the claim generally is going to be greater than if you've got a body part, an arm, a leg, or a toe, or a foot. So what is the schedule? I just kind of, again, you may know these things, but I want you to understand why, how this piece of the puzzle fits together. The Alabama Code 25557 says the schedule is the exclusive remedy. So you have to stay on the schedule when the injury is confined to a scheduled member. So again, let's just take an arm. Now, what's important here is that there is a caveat. The schedule is not exclusive when the effect of that injury, say to the arm, extends to another body part and, so that's an and, interferes with its use and efficiency. In fact, a trial court may not award non-scheduled benefits, which means coming off the schedule, without this finding. And that's the finding by the judge. So again, why is that important to me? Kind of getting back to the medical record, and at the time that we take the doctor's deposition, you have the injury to the arm. Well, I think a better one actually was the knee we were talking about the other day. So you've got a knee injury and you're working the case, and you're getting close, and all of a sudden, 8 months later, the claimant's popping up and, I've got low back pain now. Okay. The theory is, well, the altered gait because of my knee has caused me problems in my low back. The doctor's going to have to speak to that. So, was that knee injury? So was the injury, the on-the-job accidents itself that produced the knee injury, does that then extend to other parts of the body and interfere with its use and efficiency? So I see some blank faces, and I hope I explained that correctly, but why that's important to me again. So if I have a knee injury, a leg injury, much easier case. And frankly, that case is going to get resolved. Plaintiff attorneys I work with, we can resolve a knee injury case or scheduled case. But if it gets outside the schedule, then you're starting to talk about a lot more value of the claim and a lot more disputed issues. So kind of getting back to the record, if we can get the doctor to speak to what that on-the-job accident, it certainly produces the knee injury, but is that back related? Okay. Because that's going to have a big impact in the case.
And the other thing is it a temporary issue that's going to resolve and there's not going to be any long-term back issues? And if so, what is the treatment for it that we can get him back to where, he was 3 days ago where he had no back injury or no back pain?
Mhm.
So clarification in terms of, is it a part of the work injury? And if it is, if the physician opines that it is, then is it resolvable? Or is this something that because of the altered gait, he's going to continually have to deal with? So, nailing down as much as you can from the get-go, nailing down what the body parts are, how long the doctor thinks that it's going to take for these issues to resolve. Are we going to be looking at surgery down the road? If so, why are we not doing it now versus needing to do it later? Because like if you've got someone that's had an injury where both knees were injured, and one knee has a big old ACL tear and the other knee, it's a sprain strain and just needs time to heal, then he's not going to want to do that ACL repair right away. He's going to want to wait until that person can be weight bearing on the non-affected leg or the one that is just the sprain strain so that he can recover the best from the ACL. So you just kind of have to make sure that all parties that you're communicating with understand what you're seeing when you're in that office on those visits, because that's our biggest role is communication and making sure we get that documentation to these people that need it to move on with the case, because we don't approve or deny. We're just simply there to make sure we get everything, explain it, and get all the information out to the parties that need it. Now, I would say to you that Craig and I talked to this a little bit earlier. Several years ago, when I was working with a different company that no longer exists, there was an issue where we had flyers, pamphlets that we gave to our injured workers all the time. Didn't think a thing in the world about it. They supplied them to us and we gave them to them. This is our role. This is what we do. Well, one of our vocational case managers was taken to court over that because that pamphlet promised something that the plaintiff attorney said she didn't deliver. So be very careful about what you put in the hands of your injured worker or any promises that you make to them. Make sure that you've got the approval before you tell them that the test is going to be done. Make sure you leave them with the correct idea that I've got to get approval before we can proceed with this treatment. Because you do not want them to misinterpret, because there's a lot of misinterpretation already when you're dealing with them, but be as clear and concise with them as possible.
Mm-hmm. Any questions? Okay. had a few more issues I certainly want to touch. I think we're good on time, but the next slide dealt with cumulative stress. And again, really, this is more an issue for the attorneys. I'm not going to actually spend a lot of time on that, but I just wanted you to be aware again in terms of the piece of the puzzle. This would apply to non-accidental injuries. And what I mean by that is obviously we have an injured employee falls down and breaks an arm at work. And clearly we call that an accident. We can all see that. But what about these injuries where it's repetitive? He or she is bending over all day long and just, it was one time too many, got some back pain. Well, that's a non-accidental injury. From my perspective, there's a different burden of proof on the plaintiff. So again, I just put this in here. That's really not a you issue, but just kind of in terms of your conversations, or excuse me, your documentation with the doctor. And it's something we'll really go over in the deposition, but I just wanted you to be aware that there is a heightened standard when you're dealing with those types of accidents. So in terms of communicating with the physician and what goes in the record, it's important to me. I just wanted to make you aware of that. I did want to touch on psychological injuries. Mary Ann and I were talking about this. There is a code section that would state that the injury does not include a mental disorder or mental injury that has neither been produced nor been proximately caused by some physical injury to the body. So in other words, you have to have a physical injury, at which time if it thereupon produces a psychological injury, that would be compensable, but there should be some injury to the body. We've seen some cases that a mental disorder resulting from job-related stress or harassment is not compensable. Okay, so you're going to have some type of physical injury to the body. I put this in here. I think, Mary Ann, when we again were just kind of talking back and forth, you said you were seeing a lot more of this kind of. And I don't know what your experience is, PTSD or associated psychological injuries, but I'm seeing it as well, which is why I just kind of wanted to touch on this briefly and hopefully give you kind of some background as to kind of what the law in Alabama is with respect to that. But bottom line is, again, from my perspective, if you've got a bodily injury and it produces some type of psychological injury, perhaps the bodily injury can be resolved and can be worked through, but that psychological injury absolutely can support a finding of permanent total disability. So it is a big issue. The last injurious exposure rule. This is really a situation where you've got an injured worker who was with one employer, has an on-the-job accident. We get it worked through. He or she goes on and starts working for a second employer, has another injury. And, of course, both employers and their carriers are saying, hey, wait a minute, this is the old problem. And then the one say, no, it's the new one. So just again, for your background, again, documenting or your questionings or your discussions with the doctor, how that injury is characterized by the doctor means everything there as to who's going to be responsible. So if it's a new injury, the second injury, well, that second employer bought it. Okay, that's kind of clear. If you have an aggravation, keyword, all right, so, you had some back problems with the first employer, you had a back injury with the second one, but if that second one aggravated it, in the doctor's opinion, second employer's bought it. However, if the doctor characterizes that a recurrence, he or she is saying, well, yeah, it was something maybe tweaked his back with the second employer, temporary, gone back to baseline, it was really just a recurrence of kind of the initial injury, well, then it's going to be the first employer that's got that.
And that's oftentimes where I know most of you are probably going in and doing this, where we're doing, because of pre-existing issues anyway, a lot of our terminology when we talk about it, the injury with the doctor is he at baseline or is she at baseline? Are we, we know they have degenerative disc. We know that. Okay, sprain strain. I think sprain strains, I would rather see a catastrophic injury almost than a sprain strain of the back, because they never want to resolve. But going back to baseline now helps us so that we can settle it down where, okay, we know they got degenerative disc, even though the patient did not hurt before this injury happened. And even though it gets explained to them by the doctor multiple times that they flared up arthritis, the arthritis has always been there, it's not a traumatic issue, they hurt. And that's all they'll say, you know, oh no, I hurt.
Yeah.
I hurt. I hurt and I didn't hurt before. So baseline becomes an optimal phrase for us.
Yeah, and just getting back to this, I have been actually in a deposition with a friend, a neighbor who's a orthopedic physician, and we had this issue of aggravation versus recurrence, and he's looking at me like, Greg, I don't know what to tell you, but these are the words that are used in the statute. So unfortunately, these are the words that we've got to go through. So I had to define it and explain it to them. But there is a very good reason for the use of these two words in your communications with physicians in terms of what makes it into the medical record. One more topic I kind of, again, want to make you aware of with the intersection with the law is the refusal or reasonable medical treatment. And again, this is not so much, as I see it, an issue for the case manager to go and clarify, but really I kind of wanted you to understand why it's important to me. So I don't know if you've had this situation come up where you've got a claimant, it's not showing up. Marian's laughing, probably had a few of those. Not going through with treatment. I've seen that some where the doctor says, hey, you got to stop smoking. I won't, do surgery on you until you stop smoking. The claimant can't stop smoking. So is that a refusal of medical treatment? And that is important for the adjusters, for the carriers here, because compensation can be suspended during the period of time that the employee refuses medical services. But that refusal must be unreasonable. All right. So once again, we got to, what is reasonable? So reasonable is it does not have to cure the employee, the treatment, for it to be reasonable. It only has to lessen the physical disability without placing the plaintiff at undue risk for further injury. Again, this is really more a me issue, but I kind of want you to understand you're probably getting questions, or perhaps you get a question from an adjuster. Go ask the doctor, is this unreasonable refusal of medical treatment? So again, that statute is triggered again for me, for the carriers, when there's a reasonable expectation that the condition will improve with the treatment and that treatment must be danger-free. And again, that's a lot, but I kind of wanted you to understand that this seems to be an issue that comes up a lot. I get a lot of questions about it.
Yeah, it comes up a lot. I know y'all see this all the time too, where, they can't go. And again, it kind of ties into the whole COVID thing. Do they have COVID? Are they around people who tested positive? Or are they just delaying the treatment? Well, some of these things I think just are not ours to call. And so we make the adjuster aware of it, because that's where for us. And again, this is the difference between medical and legal, but it helps me at least to understand why I'm being asked to do things, because oftentimes the adjuster, when they're talking to us about things, they're trying to make sure that their file has everything that they need in it so that they can work towards whatever they need to do towards settlement and closing their file. So even though we're doing the medical side of it, it helps to understand what the legal ramifications are, at least in my opinion.
Yeah, I think that might save you a trip or two, so to speak, because I suspect that you get these questions after you've just visited with the doctor. Well, did he address X, Y, or Z? Well, again, if perhaps hopefully some of this makes some, is giving you some background as to why you're being asked those questions. So maybe those can get addressed on the front end. So briefly, maximum medical improvement, we actually talked about that. Again, just very important, as that is kind of the dividing line between temporary and permanent injury. So again, and I think we all know that now, even the doctors are well aware of that. So that makes its way into the record. So that was how a case manager kind of intersects with what I do. And so I thought more importantly to the case managers would probably they want some information on what can I do to avoid any trouble, and put together just a few slides. The definition actually was found in the Alabama Administrative Code as to the goal of medical case management. So it is to facilitate, this is kind of what the definition is now, to facilitate the organizing and sequencing of appropriate healthcare services, and this shall be done in the most cost-effective manner without compromising quality of care. Now, I'm sure everyone is adhering to that. I feel very sure about that.
I'm definitely sure.
But this is kind of how Alabama sees the goal of medical case management. And really the next slide, I just kind of wanted to present to you. Because Marianne and I'll talk. Hypothetically, what would you do here? And I'll call her and say, hey, I've got this, I'm reading this medical record, you know, what does this mean? So we talk back and forth. And one of the things for Marianne on occasion will be, well, you know, what would you say in this situation if I get presented with X, Y, and Z? So really the ethical obligations of the case manager are really found outside of the Workers' Compensation Act. But again, going back to the Alabama Administrative Code, all right, so that they say that individuals or entities performing medical case management must comply with the current standards adopted by the NARPPS. Very curious. Show of hands, has anybody heard of the NARPPS? All right, very good. So these standards that are contained within there are to be complied with by y'all doing medical case management. Second, professional performance criteria for medical case management, which pertains to workers' compensation cases. Kind of, okay, well, I think we all know that. But other national recognized medical case management standards. And I think, again, as Marianne and I talked about this, there would also, you're a CCM, correct?
CCM.
There are standards in there as well. So this is not to say to scare you, but if you have not pulled some of those out and looked at them in a while, maybe it's time to do so. I don't think that anyone's really having a problem with that, but frankly, these are the standards you're to be complied with when you're doing case management in Alabama. I think the biggest thing that I run across, again, if the ethical obligations are found outside the Workers' Compensation Act, many of these standards discuss, well, who is your client here? Okay, sure, you're getting retained by an adjuster, the insurance carrier, but several of these standards specifically say your primary duty is to the client, which is defined as the injured worker. Again, this kind of gets back to, well, you know, you should be able to do this job, no problem. You should be able to say anything to the doctor in front of the claimant. But don't forget, according to several of these standards, your duties, it's kind of a dual duty. You've got to the claimant to provide medical case management in the most cost-effective manner without compromising quality of care. Again, I think everybody knows that, but I just kind of want you to understand the legal
And I
foundation
don't
of that.
think that there's a whole lot of gray area there. I mean, I think it kind of fits well because we're patient advocates. That's why we're nurses. We're patient advocates. It is, you are advocating for that patient when you are encouraging him and working with his healthcare provider to get him back to the best level he can be or she can be. Returning to work, you know, those are things that you're advocating for that patient for, because nobody, when I worked in critical care, I certainly wanted my patients to get better and get out of critical care, go to step down unit, go to a regular room and go home and resume life as good as they could. That's the same thing that we're wanting, in my opinion, here as case managers. We're just doing it in a different venue. We're going into the doctor's office and we're still advocating for that patient. But let's face it, sometimes the patients don't advocate for themselves. And that's where I think we hit a wall sometimes, is that the patient purely has secondary gain. I mean, it's out there, it's secondary gain. And especially, again, talking about the COVID situation, you know, we've got a lot of people who have not returned to work because of COVID. And you add somebody that's already on a work comp injury and they want to keep that going and they don't want to return to work. Well, that's just purely secondary gain. But we are advocates when we are helping these patients to resume as normal a lifestyle as they can, in my opinion.
Yeah. So I would just kind of, to summarize this, the next slide, what to avoid. I don't think this would be an issue with anyone. A lot of this is just common sense, but in terms of kind of what I've seen, you know, you get yourself into trouble if you are found to be intentionally misdirecting medical care. Again, I'm not saying I've run across it, but just kind of what I've seen or heard in the community, speaking to my plaintiff attorney friends. A lot of them have a view that the case manager out there is actually directing medical treatment, given some familiarity and relationships they have with the doctors. Don't suggest that that's really going to be an issue, but you would never want to find yourself in a position where the doctor is saying X and you're saying, well, are you sure about that? Again, not an issue, but things that have just kind of come up to me.
Okay, and to speak to that, I think an example that Craig and I talked about was, how many of you ask for, when there's a referral to a specialty, especially like from occupational health, how many of you ask for a general referral to an ortho instead of a specific referral? Anybody? Just asking for general referrals? And Craig and I talked about that because I do that too. But what happens when that doctor writes a referral for a specific ortho and you're kind of going, stepping back, saying, you already have the referral in hand. Maybe even when the file comes to you, there's already a referral to a specific ortho, but you kind of want to lead this towards maybe lead is not the correct word, but you kind of want to say, can we walk this back and make this a general referral instead of a directed referral? So Craig and I have had that conversation because I have done that. I mean, I have gone back and said, hey, Dr. So-and-so, can you just give us a general referral? Because, and any of the adjusters out there, correct me on this, but even on the referral, as long as it's general, you direct where that where that patient goes, correct? Are there any adjusters out there? So I'm thinking that, this puts it back in the venue that it belongs in, for the adjuster to be able to say, hey, I'm paying and this is where I want them to go. So I don't know if we're overstepping bounds or if I'm overstepping bounds in doing that, but I've certainly done it a time or three.
No, that is one of those that could get close to the line. I think in this situation though, if you asking the doctor and the doctor is fine with the general referral, it's a little different in my mind.
Well,
perhaps some of my plaintiff attorney colleagues might disagree, but
and a lot of times the doctors are just, they're speeding through clinic, and so they're just writing it. And if you're not there, a lot of times the injured worker will have requested a specific referral. So,
Yeah. And really just to kind of wrap this up, misrepresenting facts to the doctor. So I had told you earlier that on occasion, when I get into a deposition with the doctor and the employee has not given a correct and accurate prior medical history. Again, I have not had this happen to me, but talking to some of my friends on the plaintiff side, where the case manager has come in and not given the doctor full and correct facts. And when we get into that deposition, again, it's the same thing. I'm going to get blown to pieces because the doctor feels like he's been lied to. So that cuts both ways. I don't want to overstep. I think we're right there.
I think we're right there.
I think we took up all of our time. I have a slide, or if anybody needs to reach out to me, ask some questions, and we'll certainly step out. But thank you for your patience today. Appreciate it.
Thank you so much.
Hey, everybody. We're going to give our virtual attendees a chance to win a couple more door prizes. Thank you, Sean. Okay, virtual attendees, let's listen up. Let me find my questions. All right. For the virtual attendees, here's your question. From the movie Rudolph the Red-Nosed Reindeer, classic version, what was the name of the elf that wanted to be a dentist? We're going to take not caller, excuse me. We're going to take the 5th person that gets this correct. So I'll wait on Kyle. I'm going to read the questions one more time. From the movie Rudolph the Red-Nosed Reindeer, what was the name of the elf that wanted to be a dentist?
Our winner is Aaron Inglis.
Aaron, congratulations. All right, one more. From the movie Rudolph the Red-Nosed Reindeer, what was the name of the doe reindeer that told Rudolph that he was cute? We'll take number 3 with a correct answer.
Kim Liggett.
Congratulations, Kim. Okay. For our in-person drawings, we got 2 gifts right here we're going to give away, cash prizes. I guess I left my glasses. Brenda Harris. Back over there somewhere. Amanda Ingram. Is Amanda Ingram in here?